Hello, everyone, and welcome. My name is Pia Milan Green. I am in my second to last year of law school at the University of Florida Levin College of Law, where I serve as an editor on the Journal of Technology, Law, and Policy. So I'm very excited to be here. Thank you for having me. Today's presentation, I mulled over a few topics and eventually landed on providing a snapshot of the legal landscape of the healthcare sector and what that might look like in light of AI. And I find this topic to be incredibly important. And so I thank you in advance for your time. So let us go ahead and get started. So the COVID-19 pandemic has accelerated the integration of AI technologies in the healthcare industry, right? So this encompasses remote medical consultation, patient management, resource allocation, robotic surgery, treatment recommendations, and image analysis. And so with this surge, we can start to foresee the legal issues that will be soon to follow. The first is that of physician liability in the digital age. And this is mostly in the context of informed consent and the standard of care. And so the informed consent doctrine is a tenet of medical malpractice liability that focuses on a person's decision to voluntarily agree to a healthcare treatment, procedure, or other intervention that is made by a healthcare provider, right? And there are two competing standards in the United States, that of the majority patient-based standard and the physician-based minority standard. And so the distinction between the two tends to dissipate when we are in practice. But the main theoretical difference is that the patient-based jurisdictions focus on what a reasonable person would regard as significant when deciding whether to accept or reject a recommended medical procedure. Conversely, in a physician-based jurisdiction, courts are more so considering what a reasonable physician would customarily disclose. And so although we don't have a well-developed body of case law on the intersection between med-mal liability and AI, the use of hypotheticals and judicial precedent can be particularly useful to us for our purpose here today. So let's jump in and let's consider this example, right? So a physician tells a patient that he or she will perform the patient's surgery, but during surgery decides to let an AI robot finish the non-critical aspects of the operation. And the question here is, has the doctor obtained informed consent? So there's a Professor Cohen, he highlights that this is illustrative of the substitute physicians issue that courts have grappled with in cases like Hurley v. Kirk, Perna v. Perosi, Grabowski v. Quigley, where a non-consented to medical professional took over medical procedures in part or fully. And so based on the trend found in the decisions of these cases, courts may be similarly reluctant to offset a doctor's liability for the undisclosed involvement of AI in carrying out medical procedures, right? And so let's jump into hypothetical 2. How should the informed consent doctrine apply in a case where an AI machine is deployed for the purposes of making recommendations after analyzing mammogram results, but was trained with data that excluded African-American women who have different breast densities from Caucasian women? There are some who believe that the formation of a standard-setting body for medical AI, like that of the FDA for pharmaceutical regulation, may provide the necessary epistemic warrant, as Professor Cohen puts it, to allow physicians to offset liability, and may require them only to disclose that they will be using the regulatory body's pre-cleared technology. There are some, however, who believe that whereas the clinician may not be able to explain, the workings of the smart healthcare technology with granularity, or the use of composite data sets for training, they may be required to disclose information pertaining to the AI's experience with the specific procedure that it is proposed to undertake or participate in. And so Johnson v. Cookmore, a Wisconsin Supreme Court case, kind of provides the basis for this proposition. And in Johnson, it was held that a reasonable person in the plaintiff's position would have considered a doctor's lack of experience in performing a particular surgery material in making an intelligent and informed decision about the surgery. Additionally, a handful of courts in other states have also held that the information about a provider's credentials or experience with a given procedure may need to be disclosed, especially if there's an increased risk of injury. These decisions sort of represent the minority opinion, and courts, in my opinion, may choose to treat with AI differently because of the risk, right? That this may open the door to synthetic personhood and the attribution of agency to AI machines. And so there's some broader standard of care issues on the horizon as well, concerning over-reliance on AI as a tort in and of itself. This idea that doctors in particular may be unable to resist the allure of technological dependency, and that as AI becomes fully integrated into clinical care, the physician's standard of care may rise to encompass a duty to critically assess the recommendations of AI systems. So these are just some issues to consider when we're dealing with physician liability. And so lastly, this discussion today could not be concluded without at least mentioning one of the big data privacy right aspects of smart healthcare. And as we know, data is the oil that runs AI machines. Traditionally, we know healthcare data was particularly difficult to gather, right? So apart from the issues of formatting and inaccuracy and unreliability of the data collected by hospitals and other traditional sources, there are many protections around medical data, most notably the Health Insurance Portability and Accountability Act, otherwise known as HIPAA, right? And this is a federal privacy rule that handles the exchange and security of health information. The caveat is that the rule only applies to identifiable health information, right? So to avoid liability, most health information custodians de-identify health data by removing specified identifiers of a patient, like their name, their address, their telephone number. And by removing this from the data sets, right, the remaining data is given safe harbor protection from HIPAA purview. However, as artificial intelligence is capable of now re-identification, right, by making correlations between the data gathered from fitness trackers or identified information such as internet searches and consumer records. And we can even look at Target, for an example. That's a huge American retailer that used shoppers' habits to infer pregnancy. And so with these kinds of capabilities, we're finding that the HIPAA protections are weakened, right? And the provision is arguably becoming more illusory and may empower bad actors to forfeit the privacy of citizens in favor of what they consider to be innovation. And so as we wrap up here, it is important to note that liability for AI in healthcare will be influenced by explainability, transparency, and predictability of AI systems, right? The willingness of the courts or the legislature to extend personhood and agency to synthetic autonomous beings, the social attitudes toward artificial intelligence in terms of trust, accountability, responsibility, and the trade-offs, right, between privacy and innovation in pursuit of advanced healthcare. Thus, there is no certainty as to how the legal questions will be settled by the courts, but it behooves all stakeholders, all physicians, providers, developers, and sellers alike to apply ethical principles in the deployment, development, and use of AI systems in the provision of healthcare, with an ultimate view to mitigating harm to patients. And so it has been an absolute pleasure getting to speak at the second AI for IA conference. To those of you who tuned in, thank you so very much. I hope that these 10 minutes were informative and at the least thought-provoking, and I look forward to continuing the conversation with some of you beyond this forum. So enjoy the rest of your day. And again, thank you so much for listening. Bye-bye.